So, should I start speaking now?
No, not yet. Let's see. I believe we're getting live now. Yes, it may all start.
Welcome, everyone. I'm Joaquim Muniz, one of the organizers of the 10th edition of the Rio Pre-Moot, together with Isabel Miranda, Daniel Graham-Baum, Lucas Mendes, my friend Gabriel Corte Real, who's going to be the host of the session, and Luisa Paulina. It's a great pleasure to do this 10th edition. Like, we started a small move, complementary to the famous Brazilian moves, the Curitiba Pre-Moot, organized for 20 years by Professor João Bosco Lee, and the Kansas CBC Pre-Moot in São Paulo. And in this edition, we managed to be the largest Pre-Moot ever in Brazil. We're going to have this Friday, Saturday, and Sunday, 50 universities, 150 arbitrators, and more than 500 students. So thank you, students, coaches, and arbitrators, to make this dream come true. And for the first time, we're going to have prizes in dollars. The winning university will win $1,000, and everyone that goes through the final rounds will earn a prize, and the 5 best speakers also earn a prize. So that's going to be the best Rio Pre-Moot ever. And traditionally, we start with an opening ceremony where we discuss the case. So this time we'll have 3 very experienced practitioners and former coaches of universities to discuss this very interesting case. We have Laura Zimmerman and Marcus Altenkirch from Baker McKenzie. Laura is from the New York office. Marcus is from London and the German offices. He's very international counsel. And we have our good friend Bernard Poch, an organizer of the Rio Pre-Moot since the first one, and former coach of the State University of Rio de Janeiro. So I thanking you all. I pass the floor to Gabriel, who's going to do the heavy lifting here, moderating, and thank you, Gabriel. I think we'll make it possible to broadcast the announcement of the finalists this Saturday at 7:30 p.m. So before you go partying, watch us tomorrow at 7:30. And during the Sundays, we're going to broadcast quarterfinals at 10:30, semifinals 12:30, and finals 4:30 p.m. So we're going to have very busy weekend, and I wish all the luck for you, Gabriel. Thank you.
Thank you, Joaquim. It's truly a pleasure to be on the opening ceremony of the 10th Rio Pre-Moot. I have participated as a Moody for 3 years in a row, the past 3 editions, and now is my first year as a member of the organizing committee. So it's truly a pleasure to be in this position. And as Joaquim said, we have a very experienced panel today with experts in arbitration. And since Joaquim have already introduced them, I will just skip to the chase and present how this debate will occur. Basically, our panelists will put an inquiry to all who are watching so they can participate and express their opinion on the most controversial issues in this year's problem. And they will then weigh their own opinion on these issues. If you have any questions that you wish them to address, you can make the comment on the YouTube channel, and I will relate to them the question, and so they can address it directly. So with this in mind, I will now, I believe Marcus will have the floor. Yes, thank you.
Yeah, thank you very much. Let me share my presentation with you and the participants. we were invited to give the introduction to the Pre-Moot, and as Joachim said, to discuss the case. And we would like to do it with you. We would like to do it in an interactive manner and fashion. Maybe some of you have already participated. Last year, we did something similar last year. And we use this platform called Mentimeter. And what I ask everyone to do is now to use your mobile phones, something that you normally shouldn't do when you are listening to a presentation, but use your mobile phones and go to the website called menti.com, menti.com. And then you will be asked for a passcode. The passcode you'll see here, it's 68912797. So I'll do it myself now. I can see the first ones are registering. Okay. And now we would like to go through a couple of questions, or a few questions that we have and would like to discuss with you. The first one is this: who knows the Wismut problem best? The teams, the arbitrators, or the coaches? Okay, there are some coaches participating as well. That's very good. So we wait for a few more answers. And now you know from this screen, you know why we do the opening presentation as we do it today. Because, to be frank, we thought the same. We thought that the teams know the Wismut problem best. So why do you ask some arbitrators like like Bernard, Laura, and me, who have read the problem, of course, and who will be arbitrators in Vienna or in Vindobona? But no one knows the problem better than the teams do, because you have worked for half a year on that problem. And so what we want to do today is we want to get your intelligence, and we want to share knowledge in this introductory session, share knowledge among the teams, and so that you see what are others thinking, what do they think are the strongest arguments, what do they think is the strongest position, so that you come prepared in the Vienna or Hong Kong competition. Okay, so we have quite a few people who are registered now. I can see that and participating. So we have a clear majority, and now we start the real survey. That was just the test question. So as I mentioned, we briefly want to go through the problem and get like a little bit understanding of what you think of the problem. And the first issue in the mood is, does the tribunal have jurisdiction? And I asked you to not to say what
I'm sorry to interrupt you, Marcus,
yeah,
but I believe in the screen that you are sharing, we're still on the welcome to the Rio Pre-Moot screen. So we're not seeing the...
you can't see the... Oh, sorry. Okay.
We have not even... I thought you were still waiting for the responses for the first question, if everyone who knew most, but now I see that we're skipped to the next. We're still on that first screen, so...
Okay, then let me stop sharing. Okay, great. Thank you for letting me know. Can you now see the result of the first question, Gabriel?
Yes.
Okay, sorry, that was a bit unfortunate. So you didn't see where the live results, but we'll get to that. So that was only the first slide. Let's go to the...
At least we see that we have one arbitrator watching.
That was definitely a clear majority.
A clear majority for the teams. But now let's start the real poll. So the first one is, does the tribunal have jurisdiction? And we already have quite a few votes on this one, but everyone who has not yet voted, now is your chance. I think it's a tricky one, actually. We're going to discuss it a bit more in detail later. Now we just want to get a first, as I said, first indication. Bernard or Laura, if you already want to jump in here, don't want to wait for later, feel free. Otherwise, I'll go through the 3 issues and then we break it down.
Yeah, it looks like we might have more claimants on the on the viewing side than respondents. But
yeah. Okay,
it's a very pro-arbitration crowd.
A pro-arbitration crowd, Bernard. That's true. Yeah. Okay, let's wait for 5 more seconds. Let's see whether we have a few more votes, but it's a quite clear result that claimant seems to have the better case on jurisdiction. There are just more options, I think, to how to arrive at that solution. Okay. So as an arbitrator, in a real case, our participants in the pre-moot seem to say that they would confirm their jurisdiction. Let's go to the next question, the next issue. Is there a sales contract? We'll go later to the question, when was it formed, if at all? Was there a sales contract?
Neck and neck.
Yeah. So what's the point, dear claimant, if you have win on jurisdiction, but you don't have a sales contract? That's not a big victory then. In the mood it is, but maybe not in real life. Close call. Laura, what have you voted? I don't want to influence the crowd now, because we said earlier the arbitrators have no clue anyways. But what did you say?
I said no.
You said no. Actually, me too. Bernard, are we on the?
I said no also.
Oh, we all agree. Can you imagine? But the students who know the case best, they seem to disagree. I'm now waiting for a push on the no. Like, let's see whether we get some more votes on the no after we. There you go. After we disclose that we think that from a practical point of view, there's probably no contract. Okay. So at the beginning it was a close call, but now again we have more claimants participating than respondents. Last issue. Okay, 2030. Have claimants' general conditions of sale been validly incorporated?
Okay, respondents prevailing with this one.
Yeah, so, okay. That seems to be the issue for the respondents. I don't know if it's for you also, like, or when you were coaching or participating in the mood, that was a big issue, like whether in the elimination rounds, your claimant or respondent, what is the better position? Usually the organizers say it doesn't matter whether you're arguing the stronger or the weaker position, because they say that's not what is rewarded by the arbitrators. But I have to say, when I was sitting in panels, sometimes arbitrators who were maybe not that experienced, they sometimes said after the hearing, oh, that was a really weak argument, and I don't believe that here in our case, general conditions of sales were included. And I always had to remind them, listen, it's just the more difficult position, so you shouldn't judge on that, but on the basis how well the teams did who had the tougher job. So, okay, at least what is good here is not all issues are better for the claimant. I think that's important. So some issues are easier for the claimant to argue. Other issues are easier for the respondent. Okay, so that was now a first vote. Now let's go into the nitty-gritty details, at least 6 of them or 5 of them that we prepared. We start with the first one. If you're a claimant and you have only time to argue one option, on what date would you think the contract has been concluded? And we heard earlier that most of you think that there is a contract, that the contract was concluded. So when was it? When was it concluded? Claimants, let me think about it too. But we also said earlier that there was no contract. So now we have to, what do we think is the strongest argument, Laura, Bernard? What is the strongest? Let me think about it.
Well, Bernard, what do you think?
I agree with the team so far.
Yeah.
9 April is if you do not have the time, 9 April is the easier one to make, clearer one. It seems to me that the discussion on whether the additions were relevant or immaterial is an easier one to make in a short time, and you can use heavily the case files. The ideal one would be for you to argue more than one option, but if you do not have the time, I believe 9 April.
Yeah, I voted the same. I think it's honestly, I think it's in practice it'd be quite a difficult argument to make, but I we do have the opening email from the respondents about an order, and then asking for the contract. The contract comes back with the terms that have been discussed between the parties for the most part, although not without some difficulties that would bother me quite a bit. But I think that makes sense as a good single option argument.
I disagree. I think it would your best shot is 3rd May. Actually, I think that's because before that it was always a reservation. Okay, I need to send it for signature, showing we need to sign it, otherwise nothing is binding. There will be some issues with the arbitration clause we have to review. I don't like the argument that this would be just an amendment to a contract that was already, like if I say I have to look at it, whether this is acceptable to us, meaning I can't decide it by myself, but we have to make a decision on it, on the, I think, nitty-gritty details, but still. But what I think is a strong point, or reasonably strong point, as I said, I think there's no contract, but a reasonably strong point is that the party started performing the contract by discussing a letter of credit. I know these people don't have a POA and they are like an assistant and someone else, but this is, of course, this is conduct that the parties feel bound by the contract and therefore start performing it. So I think that's actually the strongest. And I wanted to say the most difficult to attack, but that's probably not true. I think there are very good counter arguments against the 9th April on the facts, and there are very good counter arguments against the 3rd May 2020. What I just want to add is, like, I know, and I've done the moot many times, and I've read many commentaries on the CISG where I read about usages and practice that is established between the parties. I've never seen it in practice, actually, that someone wins with that there was really a practice established that contracts don't need to be signed, for example. Like that's really a high bar to show that there's a practice, even though I send contracts to sign, that they are not signed. I would rather say you run a huge risk if you send over a contract, it's not signed, you start performing, that it later is not argued that the contract was invalid and parties just performed on the basis of let's give it a try and running huge risks that this is a very uncertain basis for contractual performance. All right, so let's move to the next one. Bernard or Laura, this is yours, Bernard, isn't it? Okay.
Yes, that's mine.
Wait, let me move to the next question.
So as claimant have only the time to argue a single option, would you rather argue for the incorporation of the standard terms under the inclusion in the offer, that is, me reference, make available test, or would you rather argue under the establishment of a practice?
And we already know from the earlier question, this is an uphill battle. It's an uphill battle for claimant. Most teams and probably also the arbitrators will think that the conditions of sale were not included.
Quite close.
Yeah, interesting. That means also you'll see many different arguments also to the teams. Lesson learned, you have to prepare for all sorts of arguments as a respondent, because there seems to be not one correct answer to that.
Yes, I think we have enough votes. If I would have to argue that point, have no time to argue both options, I will have to disagree with the majority and say that I would go with the practice argument. Although Marcus just stated that it's not very common in real practice, it seems to me that this point is already a weaker one. Let's say it's already a more difficult one for a respondent. I believe when you go to it being included or not in the offer, you have too many options for a short time. You have to make arguments as to the positive knowledge of the make reference theory or the make available test. And it seems to me that you face some of the same hurdles if you go through practice or inclusion of the offer. And practice is more straightforward, is a cleaner argument to make, at least orally. On both, either in the inclusion in the offer or practice, most likely have to face the issue that the practice was established while the negotiator was still in another company. But I think for all arguments, the practice argument is easier to make on a short notice. But ideally, once again, you will have the time to argue at least one of the points of the inclusion in the offer, maybe the positive knowledge for claimant. But if you only have the time to argue one of the two, I believe the practice is more straightforward. What do you think, Marcus, Laura?
I honestly struggle with the answer to this one. I think it's really difficult. I think the inclusion in the offer bothers me just because I feel like it wasn't available. So how can you include something in the offer that the other side does not know what it is? And the practice point, I have the same issues as Marcus, but at the same time, it's a bit more sympathetic, I think, for claimant that the respondent and the person making the decisions and with the authority on the respondent side really knew all the elements that she needed to know, or at least that's what you could argue. So, just thinking about it in terms of equities, on the practice side, maybe that's a bit more sympathetic for claimant than including something in an offer that wasn't actually made available in writing.
I disagree, my learned friends. As I said earlier, practice is for me like a wishy-washy argument. And yeah, it's equity, Laura, you're right. If the arbitrators feel that it's not fair, that it's a certain result is not fair, they find certain solutions like established practice. But I think as a team, but I have no clue. But I think I would go with the majority here. I would argue that it was referred to in the offer. And remember, like now we're talking about a scenario where the contract was concluded. So the claimant has already won that point. The contract was concluded, and the seller says here, I'm selling you the products on the basis of my terms and conditions. And then okay, I know that's not the majority view under the CISG, but then I have to ask for it. Let's suppose you sign something, you sign a contract, you sign an offer, which says the sale is pursuant to my terms and conditions. You sign it, and then later you say, but you didn't provide me the terms and conditions. We're not talking about consumers here. We're talking about commercial sale. I would say then it's the job of the purchaser to either strike out that line and say, no, we're not selling according to something that I don't know, or we don't include this as a term in our contract, or I have to do some homework as a purchaser and dig them out or ask for them. So, and I could imagine that it's also easier to argue in the mood. You go like for principle. You go say, listen, this is what you have to do, and then here it says it's pursuant to our conditions of sale, and the other one is of course much more fact specific. The practice. So, next one. That's
right.
So, for you,
So,
Laura.
right. So, as the respondent, is it worthwhile to argue that there is no arbitration agreement under the law of Danubia Equatoriana or Ruritania? So obviously, there's going to be arguments about Mediterranean. But if you, considering your time restraints, do you think it's worthwhile to also make these arguments that there's no arbitration agreement even under one of these other laws? Or conversely, would you rather just concentrate all of your time on arguing about the law of Mediterranean?
Very technical question, this one. All right.
Yeah.
Good.
So I leave a little bit of time for the answers to come in. I do think this one is a tough, but it's actually, I think it's a good question because it really gets at something that you have to struggle with in the moot and you have to struggle with as an advocate all the time in real life. You will know your case better than anyone else, certainly better than the arbitrators, or you should know it better than the arbitrators. And it's really tough when you have good arguments to leave them on the table, right? And not to make all of your arguments before the tribunal. But streamlining and making tough choices about how you're going to use your time is a really important part of practice. So especially if you have, a chess clock or some kind of time constraint in your proceedings, which you almost always will. So I've seen many times, both in the moot and in real life, where parties try to squeeze in too much, right? The advocate tries to do too much, and the end result is they either run out of time, they end up speaking way too fast, which, especially in an international context, can be really problematic. No one can understand what you're saying if you have, they have a different accent from you, or their English isn't their first language. That can be a real problem. Or you just fail to get into the depth that you need to capture the attention of the panel. So you really need to figure out, what's going to actually serve you in a hearing setting, and be comfortable with the fact that you've covered other things in your written briefs that the tribunal might need to think about. So here, I, disagreeing with the majority, think the respondent has, some good arguments to make on jurisdiction. So if I were the respondent, I would probably find it worthwhile to at least discuss the law of Danubia as the law of the place of arbitration and the substantive law mentioned in the general conditions of sale. But, and at the same time, that's going to be the argument that claimant will make, their main argument, that the conclusion of the arbitration agreement is governed by the law of Danubia, because the reference in the contract to the application of the GCOS was, they have the best argument under the law of Danubia that it would be sufficient to include it in the contract. So, I think that it makes sense to spend a little bit of time on that. But I don't see any reason to discuss Equatoriana or Ruritania. I think that would probably not be a good use of your time, unless you're really streamlining other things and you've got lots of time for this. I would probably skip any in-depth discussion of those two. But for me as an arbitrator, I would still be skeptical of the fact that the GCOS was not really provided in its latest form to the respondent. So, it's a bit unusual. So I think it's a bit unusual to have the conduct of the parties and practice be applied to formation of contracts, in my experience. So some quite interesting arguments to discuss here, but I'm curious as to Bernard's and Marcus's point of view.
Okay, Bernard, you go ahead. You go first.
Okay. I have to agree with Laura. I believe that it is worthwhile to, at least for 1 minute or two, to argue another law. And as we'll see on the next question, I also agree that should be the law of the Nubia. I'll go in more details in the next question. But considering that as respondent on jurisdiction, maybe you speak first, it can be useful to preemptively shoot down maybe the most likely the main argument that the claimant is going to make, even if you focus more on what would happen considering that the Nubia law, the tribunal decided that the Nubia would apply, and maybe would focus on that instead of whether or not the Nubia will apply or not, because if the tribunal follows your argument in Mediterranean, that will already be dealt with. But maybe address for a minute or two why you think that if the Nubia law applies, the arbitration agreement still does not exist or is not a valid one.
I agree and disagree. I agree with what Laura said that, there are time constraints, especially in the mood. There's not a lot of time. You'll get a lot of criticism if you don't finish on time, even more than in real life. And no one will complain if you finish 1 or 2 minutes earlier. No one. The same here probably in this opening presentation. If we finish 2 minutes earlier, no one will complain. To the contrary, they will say, "Yeah, I learned something. Was interesting debate, and we got 2 minutes back of our life." So I would recommend teams to rather finish earlier than later. And moreover, on Danubia, you could address it in questions if the tribunal is interested in Danubian law, and I'm pretty sure most of the 11 participants who said no, we concentrate on Mediterranean, you can argue it in the rebuttal, of course. But you're right, Bernard. Like, the respondent will probably go first, and my advice would be, that's why I would say I disagree or maybe disagree. I would focus on the strong points. Because also in the mood, what I've seen is like you get rewarded for your strong points. No one will reward you for a complete argument on all layers. Of course, you have to, if there's a question, you have to respond to the question. But no one will check. This is argued. But they just sit there and listen to the arguments and say, "Oh wow, these were strong points. It was a very good presentation," and make their decision and give points on the basis that impression. So if you have a very, very strong point on Danubia, and I'm not sure if you do, that there's no arbitration agreement if Danubian law is applicable, then yeah, if you have a strong point, then yes, it's worthwhile. Spend the 1 minute, 2 minutes on that. But if it's rather a struggle and you get many critical questions by the tribunal, sorry, why do you think there's no arbitration agreement under Danubian law? Then do it in the rebuttal. Then it is complete. You get that check for complete argument. You erased it, but no one will, or not no one, but you won't get many questions, critical questions in the rebuttal by the tribunal. So in this mood scenario, I would really go for the strong points and finish 1 or 2 minutes earlier.
That's a really good point about saving some point. If you only have one strong point to make on it, and then you make it in the rebuttal, there's nothing better than having, a really snappy rebuttal that's like a minute or less, 30 seconds. That's always, really powerful if you can do it well. So that may be a good
yeah,
way
and you can say like, my learned friend has now just spent half an hour explaining that it's not Mediterranean, but Danubia. All right, if it is, I have a very strong argument why even that doesn't make a difference. It's all irrelevant because even under the law of Danubia, there's no arbitration agreement. But to be very frank, I don't even know what the argument would be. But if you have a very strong point, then yeah, you can raise it in the rebuttal. Shall we move on? Or
just a brief comment. The only problem I have with that is that I have some doubts if rebuttal, if there is a strong and snappy argument on why there would be no arbitration agreement if the Nubian law was applicable. I believe this argument, if you do not have a question to answer for the arbitrator under your rebuttal, it's quite difficult to develop it in 20, 30 seconds. It will be an uphill battle, and most likely it will be a rebuttal that would not be that effective. So that's the reason I believe that ideally you should try to address it for 1 or 2 minutes on your main argument and leave the rebuttal. Maybe for, as Laura said, a snappy point or something that gives a lasting remark to the arbitral tribunal. But I understand the point that Marcos brought also. It's a very strategic decision to make.
Okay, then let's move on to the next question. Just by the way, for those who came maybe a little bit late and wonder what are we doing here and where do these bars come from? So everyone, if you want to join the voting, you just go to menti.com and use that code here, that passcode, and then you can join us and join us in the poll. Okay, next question. So Bernard, that's for you.
I was on mute, sorry. That's actually a follow-up question from the last one. As respondent, if you decided to argue another law other than Mediterranean on your main argument, would you rather go to Danubia, Equatoriana, or Ruritania?
That's also a good question for those teams preparing for the vote, because then you know what you have to prepare for. If everyone now says, or if no one says Ruritania, you don't need to prepare that much on rebutting that. But if some teams seem to go for Equatoriana, so that's a good important information for the teams.
I think we have a clear majority here. I don't see it reversing anytime soon, so I'll start talking. I have to agree. The teams that so far, either going through memos or watching teams argue, it's very clear that when claimant argues another law other than Mediterranean, it argues Danubia as the first law applicable as the place of arbitration. It's maybe a law that's more lenient to the conclusion that there was an arbitration agreement. So as we were speaking on, with regards to the last question, it seems to me that this is a defensive argument. The main point brought by respondent most likely will be that the law of Mediterranean applies and leads to a valid arbitration agreement, to there being no arbitration agreement. However, if the tribunal decides that, as claimant has argued, and the law applies, it will not lead to the conclusion that there was a valid arbitration agreement. I have seen some teams, particularly in the memos, arguing that Equatoriana would apply because Equatoriana is actually a better law for respondent than Danubia would be. So they give third option, let's say, for the arbitral tribunal to decide if it does not follow that Mediterranean law would apply. However, it seems to me that Equatoriana is quite an uphill battle to argue for its applicability. There's not that many connections with the dispute other than the place of the delivery of the goods. And this seems to be more relevant to the merits of the case, let's say, to the law applicable to the contract itself and not to the arbitration agreement. So if I had to decide whether to argue, for instance, Equatoriano or Mediterranean, most likely as respondent I will argue Mediterranean. So Danubia, it seems to me as a logic, it has some logic for respondent to argue it as a defensive argument in order to preemptively go against the argument most likely claimant will make. And there are fairly good arguments to make so as to why under the Danubian law there would be no arbitration agreement. You could argue that there was a lack of consent. You could argue that the agreement was not in writing under the Danubian law. You could argue that there was no specific reference to the arbitration clause and bring some scholars in case law that argue that a specific reference is necessary. So it seems to me that Danubia is if you're a respondent, you decide to argue for another law, Danubia makes sense. Britannia SBC, although it would theoretically be a possibility, no one argues, and for good reason. There's not much reason to argue Britannia here. It's bad for you. It does not have many connections to the dispute. So at least that's my opinion. I would argue for 1 to 2 minutes the law of Danubia as respondent.
I agree.
Yeah, I think it's related to the point about timing as well that we discussed earlier. So sure, you know, you might want to throw in some stuff about Equatoriana because, you know, there's some quite helpful case law as we know from the problem there on the CISG's applicability to the interpretation of arbitration clauses. But and as you know, respondent, that's your home jurisdiction. You may argue, I don't know, but in real life, I might argue, well, we never decided what the law was going to be. We were still discussing it, and I was going to argue for for the applicability of Equatoriana because you know all of these issues have been important for our company, that you know, blah blah blah. So you know, there's some things you might want to argue about Equatoriana, but as a matter of timing and just being prepared to address the other side's arguments, I agree with the majority here that you know you have to address one other one. It's probably Danubia.
Yeah. Okay, then let's move to the next question. Strategy, Laura.
Right. So, okay, so this question is whether or not the merits should be dealt with prior to the preliminary issue. So the merits being about the contract, the conclusion of the contract, and the preliminary issue being jurisdiction of the tribunal. So let's see where we get to here. Okay. Not too dissimilar split here. Oh, neck and neck. So this is an interesting question because normally, of course, usual practice we would expect to see is for the parties to start with the preliminary issue on jurisdiction. In this case, it's sort of interesting because the jurisdiction issue and the merits issue are so closely linked. Both of them deal with this inclusion of the GCOS in the main contract. And so really I think you have room to do it either way, interestingly. So in my view, it would be feasible at least to do it with the merits, argue the merits first. From claimant's point of view, I think that might have some strategic advantage in focusing the tribunal's attention on the contract and just the merits of the case right away, and you know, kind of sidelining the jurisdictional issue perhaps. But from the respondent's point of view, I would be surprised to see anyone wanting to put the issue first, the merits issue first, because obviously thematically, as the party opposing the tribunal's jurisdiction, that is the issue, right? That is what the tribunal should be focused on before engaging with anything else. I would want to very stridently oppose jurisdiction in this case. So I think it's really a matter of strategy for the parties and where they think they can make an impact first, perhaps. But Bernard, Marcus, what do you think?
Well, like usually the rule is strongest point first, right? So I want to start strong. And as a claimant, as we saw, at least, okay, like we were not representative, the three of us, but we didn't like the argument that there is or we thought, all three of us thought that there's no contract. So as a claimant, I don't want to start with that actually, that there's a contract, because then it's right from the beginning, it's an uphill battle. So it seems to me that claimant has a better case on the validity of the arbitration agreement, and then discussing, is it Danubia? It is Danubia. So I think if I'm a claimant, I would probably tell my opposing counsel, like, let's start with the arbitration or the jurisdiction, and then if I'm respondent, I think for the reasons, Laura, that you mentioned, I might also want to start with jurisdiction, because, well, it's just more realistic that as a respondent, I start with jurisdiction, because I don't want to go to the merits at all. It's clear that the tribunal doesn't have jurisdiction. So I think I would go with the majority view here. So do not argue the merits prior to the preliminary issue. And the third one, maybe also, which Laura, you also mentioned, most of the arbitrators in the moot, actually it says so in this analysis, arbitrators analysis, but still they would expect that the arbitration is covered first. And I think that's also a consideration. What does your panel expect to happen? And do they get confused when you start with the merits? Bernard, what do you think?
As a coach, I think I will go with the majority here also. I would say that leave the merits for the second position, mainly because it seems to me that it makes easier for your preparation. I believe you must be prepared to argue the merits first. I believe there will be occasions when the other team you wanted and the arbitral tribunal will allow it. But the median arbitrator, let's say, most likely will prefer to keep to what he is accustomed to, and that's hear jurisdiction first and then merits. However, I think that it makes some sense to argue the merits first this year. The jurisdiction issue this year is quite heavy on discussion of the CISG. I believe that if you argue first the merits, it may make it easier for the jurisdiction points to address mainly points of procedure, instead of having to go through make reference test, make available test. So maybe it clears the field for more procedural discussion later on. However, I think most likely, I would not put as the main option for my team to argue the merits first. I think that you have to be ready, because it's quite possible that on the Pre-Moot, one of your 4 pleadings, you have to do that, but do not be my main strategic option as a coach. As an arbitrator, I would allow it. I think it would be fun to see how the teams dealt with the merits going first. I believe there was another year, maybe 4 to 5 years ago, that the same issue arose, whether or not the merits should come first, but it's quite rare. So as an arbitrator, it may be at least a different experience to see the merits go first. But as a coach, I would not recommend it.
Yeah, it's tricky this year, I think, also for the teams, I imagine, in making sure that you're not overlapping, and repeating each other on your argument of merits, because there is so much overlap. So it would be interesting to see how the teams approach that.
Good point. Okay, so let me check. I think that's it. We reached the end of the presentation of our poll. So thanks a lot for these insights. I hope the teams learn from each other a little bit.
Yes, good luck to everyone. Hope we
Before-
had a little bit of fun here.
Before we conclude, may I ask a question to the panelists? Well, one of the main issues I think in this case is like a hidden issue regarding the existence or no existence of the practices. And what is your opinion regarding the fact that all the previous contracts were celebrated with another company, but involving the same people? If this would constitute a practice or not?
I find it super tricky. Like actually, I thought about it all day long today. What is my view on it? And I'm torn. I think I have a slight tendency to say, if you hire certain people and if you give them power of attorney to conclude contracts, that's your risk. That then you risk that these people continue with their practices, with the parties, purchasers, sellers that they were dealing with, and continue with that. I think that's kind of what you're buying in. You're buying in that, but it's a very interesting and tricky question.
Look, I'm not a coach. I'm not into the problem, and so I can give you my gut reaction, which is that the course of performance type arguments are usually within the context of interpreting a contract, right? So it's usually about the party's course of performance under a contract. Course of performance as to the formation of different contracts, to me, is already a very difficult argument to make, at least from a US perspective. And so I have a hard time with that one already. And then you add into it the differences between the different legal entities. To me, it's so what? There's the same people involved. Who cares? People change jobs all the time. So I think it's, it's, to me, that's the course of performance argument, while, like I said earlier, has some sympathetic effect in that, what was the actual knowledge of the parties? Did they actually know what they were signing up to? That is somehow like a stronger argument to me than a course of practice as to contracts that were, formed, formation of contracts. And to me, there's no, it's hard to argue that just because you signed up to a contract in the past, you're obligated to sign up to a contract in the future, under conditions where you haven't actually signed anything. So that to me is a tough argument to make. But
the thing is, isn't it like, okay, like first of all, as you all know, I don't agree that there was a practice established here, and that I wouldn't follow that argument. But if you say there has been a practice, let's say these two people have dealt with like that forever in the past, and then the person changes jobs or changes to a different entity, isn't it then formalistic to just say it's a different entity, let's say in the same group of companies, and maybe just change the name? It's she's sitting on the same desk at the same office, and just because of something above her in the control structure, so to say, change, now there's no custom or custom anymore. As I said, I'm undecided. That's why we
have formalities. That's what the law is all about. But that's coming from a New York lawyer, where we say, a contract is a contract is a contract. Very different under other jurisdictions. So
I believe I have to agree with Marcus, but for me, the main point here would be that it's kind of strange, for instance, for the person that responded higher to act as the practice was still valid, let's say, if he's concluding another contract, disregarding that he changed company, let's say, does not bring that up. I believe if respondent has hired him and kept him and he has to take responsibility for the acts of its representative, its the negotiator. I believe it would fall on the negotiator to say that please be aware. We are not dealing with the same company as before. I'm here in a different position, so let's begin anew. From the day that he started to negotiate the contract, using the same knowledge he had, using the same posture he had prior to that negotiation, and then respondent argues, oh, okay, but that's a different company. I think it's a little bit too formalistic, as Marco has said, but it's
I completely
disagree.
I completely disagree. I think it should be not about the particular people involved so much as what is the control of the corporate entity over the subsidiary entity, because what we're talking about here is a course of performance of the parties. It's not a course of performance of people. So to me, as an arbitrator, that's what I'd be looking to see. How do you make the argument about the legal entities perhaps being, they're being too formalistic of a distinction between the legal entities rather than so much the particular individuals involved. But that's, again, my perspective coming from the US.
Well, thank you for your opinion on this. I personally tend to side with Laura on this issue. I think it's a bit formalistic, but I believe there are different companies, and the practice should bind the companies and not the people who are negotiating in particular. But we have another question from the chat on YouTube, and I would like to read to you. Would you consider persuasive that the teams address the environmental issues alleged by respondent, considering breach is not an issue to be discussed at this stage in the proceedings? So Marcus, wish to start? Bernard?
I believe as an arbitrator, I would most likely interrupt the speech if this began to be argued. It seems to me that the case file is very clear on which issues need to be addressed. I don't know why we would address the environmental issues alleged by respondents at this stage of the proceedings, considering that the parties agreed that they would only discuss whether a contract was formed, whether the standard terms were incorporated, and then whether or not there was an arbitration agreement. So as an arbitrator, most likely I would ask why he's bringing that up, the speaker is bringing that up. If the parties had previously agreed not to deal with this issue on that hearing.
I agree.
Yeah, I agree. I mean, I don't think it would be worth obviously going into the arguments about whether or not that was, a breach or cause for termination or any of those things, because obviously that's not included. However, you might find, some thematic, in your opening or some kind of thematic way to bring it in if you think it's a sympathetic point for one side or the other. So I could see, adding some flavor in, these arbitrators, it's always kind of good to get the flavor of the dispute and kind of hear the parties' views on where things are going to end up. So yeah, maybe you could work it in somehow. Might make it more interesting, but I wouldn't spend a lot of time on it.
So you would put it on like an opening statement to give flavor to it, but not address it on your actual submission.
Correct. Yeah.
Yeah, I think for respond, that's not a bad strategy. And I think these are all questions. So I'd like to thank you all for being our panelists today in the opening ceremony. I will finish the live stream now.
So let the game begin. Good luck to everyone, and thank you.
Good luck.